All right, you're watching Standing on Guard here on Decision 2017. We have a panelist already with us in studio to weigh in on that story and a raft of other issues as far as security is concerned as well. But yes, we want to talk about also what was happening at the Supreme Court yesterday. And allow me to introduce to you this morning the professor who's the Vice Chancellor of KCA University and also an expert on defense and foreign policy. This is Professor Noah Midamba. We have with us as well Dr. Mustafa Yusuf Ali, who is a conflict resolution and national security expert. Also, we do have with us Dr. Oliver Kisaka, who is a chaplain and also a lecturer at the African International University. We have with us as well Captain Werunga Simiyu, who is a CEO of African Security Studies and Strategic Studies as well, this morning to take us through a raft of issues that we'll be discussing this morning. But first, let's just begin with this particular issue of a Supreme Court and the Attorney General saying that the precedent that was set there in 2013 should not be done away with. It should be also a very key element in deciding the winner of this past election that we just had. Let's begin with you, Captain Werunga, so far. Do you, first of all, agree and hold with his view that we should not set a new precedent?
I did not understand him, so I have no comment. Because I don't understand which president was set in 2013. So I really don't have a comment on that.
All right, let's hear from Dr. Oliver Kisaka.
I think the opportunity that exists before the people each time they come to a difficult situation like this, first is to say that the petitioners this time round began making noise very early. They were expressing jitters about what happened last time, meaning they were not satisfied. It doesn't mean necessarily that the rulings were wrong. They had a problem with it. When we talk about justice, we normally say it not only needs to be done, but it needs to be seen to be done. So in the event that you have a situation where a party has expressed dissatisfaction of the past and a similar situation arises, it's prejudicial to tell the sitting judges that you must conform to what happened. I think they should have the liberty to examine all the laws according to the expertise and integrity of their capacities, and to be able to say whether or not to agree with what happened in the past. They are in effect answering, why are you right to doubt what happened last time? And if there is sufficient ground, future courts must not be held to a wrong decisions that was made. Otherwise, there would be no sense in the whole systems of appeals.
Yes.
In the case of Kenya, only the Supreme Court has the capacity to overturn a judgment passed by the Supreme Court. No other court lower. So if there is no appeal beyond the Supreme Court of a matter that was done in the past, and you are before the Supreme Court, then where else do you go as a Kenyan if you have not seen justice to be done? So regardless of whether or not the ruling in the past was right, any party that feels aggrieved has the right to question whether that ruling was actually right or not.
All right, and maybe also just to refresh your memory on that particular ruling, just elements of it. In 2013, the court established that the burden of proof in an election petition lay with the petitioner. An enunciation of a general rule in civil cases, which is to the effect that the plaintiff or the person that files a suit in court assumes the burden of bringing evidence that will prove the case to the satisfaction of a case. While this rule is responsible in ordinary civil cases, its application, according to some pundits, in electoral disputes brings up the challenge that a petitioner who comes to court is required to prove a case against the Independent Electoral and Boundaries Commission when the Commission is the custodian of all relevant records relating to the election. And then they say in such a situation, the petitioner is at the mercy of the Commission when seeking documents that will support the petition. It is possible for the Commission to fall into the temptation of delaying or blocking blocking access, I should say, to its records as a way of defeating the petition. And of course, we can see this actually was a state of play, according to the petitioner, that they were delayed in terms of accessing that particular information. And even yesterday, they were saying all the orders that were given by the Chief Justice were not really followed to the T. Right? This we can say also was claimed that the logins were not given, and a raft of other issues that were laid. So in his advisory as the Attorney General, who is supposed to be the arbiter and a custodian of this constitution advising the government, do you think also he was none the wiser in advising the court that they should actually, you know, not shunt away what was actually, as Dr. Kisaka is saying, given in 2013 or ruled in 2013, and use that maybe as or predicate this particular case in light of a particular case in 2013, Dr. Mustafa?
Debarl, I'm not a lawyer. I'm not a political scientist.
Of course.
I'm afraid that I might confuse Kenyans if I comment on that case or the issue of precedents. But from the little understanding that I have on legal matters, and if I'm to apply my own background, when we are talking about precedents, precedents is something that is, it can be quite dangerous and also quite good. It just depends with the circumstances. If the issue at play or the issue that was being judged was deemed to be fairly judged, then precedents become something that is called for. But if the judgment that was articulated by the judges was deemed to be unfair, and that then is used as the principle of precedents is used, then it becomes very difficult for many people. And I would always go for the facts at hand, present, the issues at present, the context, and issue judgment based on those facts that are before the courts, and not care much about precedents. I saw some of the lawyers were arguing about precedents in some county elections or borough elections in the United Kingdom, and I was wondering, you know, how can that even apply in a presidential election in a post-colonial country such as Kenya? That's my 2 cents, a point and view about that, Debarl.
All right, thank you. Let's hear from Professor Noah Midamba.
Debarl, I'm not a lawyer, but I'm a political scientist. I want to bear out a little bit away from focusing on precedent or not precedent. And here's the reason. Kenyans need to take this issue very seriously as a matter of national security. Should we move ahead as people of the Republic of Kenya, make progress and make substantive development? Or should we, every 5 years, retreat back 2 or 4 steps back because we are fighting each other? Debarl, I'm very proud of the way the new Chief Justice has conducted himself, the manner of which he has managed the court, and by gagging 2 principles was one of the most wisest decisions, so that there is no unnecessary noise on the side as the proceeding was going on. I'm very proud of some of the outstanding lawyers that I've seen before the court and the way they have conducted themselves. And secondly, Kenya ought to be very proud of watching the 2 senior counsel last night, both James Orengo and Paul Mwite, in their summation. They were respectable of each other. They were respectable of the court proceeding. And that ought to set precedent so that we don't go back to 2013 simply because a number of things happened.
Yes.
Lastly, whatever the outcome of this proceeding, let Kenya remember one thing. We must move ahead as people, and we must respect the court outcome, and we must be law-abiding citizens. That is my 2 cents.
That is your 2 cents. All right, maybe you can add your 2 cents also on the editorial cartoon that we have in the Standard this morning on page 14 of the Standard, and of course, looking at the circus, according to Gado, that was in the Supreme Court. Yeah.
I think there was a few theatrical moments, but I think this more reflect 2013 as opposed to 2017.
You're right.
It reflects Parliament, actually.
Yeah.
The last Parliament.
Yeah, that's what that is.
Not on the Supreme Court. Oliver, you had to say something.
Yes. I would actually go with Professor Midamba in appreciating the way the court has managed this process so far, and the way our lawyers have distinguished themselves as respectful, seeking to argue their cases rather than to... I'm not sure. I wasn't able to watch these proceedings fully because of official responsibilities, but I'm not sure what happened is depicted by this cartoon.
All right. Let's hear from also Captain Werunga. There was drama, and I know you also can flip to, I don't know, page 4 of the Standard. 14 of the Daily Nation. Not the Standard, the Daily Nation, where we had drama also with one of the minders of Senator Moses Wetang'ula, right? And of course, we know that he has actually been stopped from serving the National Police Service as well because of that particular drama. Do you think this was warranted in the first place? I think I'll flip over there in a moment. But you know the gun drama that was there at the Supreme Court.
I think let me also mention about the court process. I think what we remember about 2013 is that some lawyers took charge of the Supreme Court and actually directed the court. And we will notice that at that time, some of the members of the Supreme Court felt actually intimidated. You will see some intimidation in them. We noticed very quickly in this one that Chief Justice Maraga took charge, and I saw at some point where the Attorney General was trying to come in with some uninvited and solicited comments, and the Deputy Chief Justice quickly mentioned to him that those decisions are going to come from us. And I think that is what set the pace and the momentum in this petition this year. And to me, that was a very good thing, because we know some of our lawyers in this country have this tendency of trying to intimidate judges, and we did not see this one. It was a very good thing. I think the judges took charge of their process, they managed the process, and even at the times when we were seeing those altercations, you notice that the Chief Justice will quickly come in and give direction, which was a very good thing. And I think that's why you saw a lot of semblance. And therefore, with that cartoon, I do not understand what it really means. Maybe I'll go through slowly. But I know that actually this time the court took charge of its process and managed it very well. And now, secondly, to this guy, the police officer, I want to look at it in two instances. One, I saw a senior police officer actually pushing this junior police officer. And as a person who has been in uniform, I cannot fathom how I can go and lay my hands on a junior officer, pushing him, trying to rough him up. So from a point of leadership and command, that OCPD failed completely. That is one. And therefore, even as they go ahead to sack this officer or not sack him, we don't know exactly what has happened. I think the impact of that senior officer pushing a junior officer was completely irresponsible. And it has a serious impact on how junior officers in the police service will be viewing their senior officers, because that is completely unacceptable in terms of ethics and leadership. So that is one, and I think we need to emphasize on that one. It gives you a semblance of even how this officer then manages his division. Because I saw an officer, I think it was a chief inspector, a lady and a man, and they were looking at their OCPD pushing this officer, the bodyguard, all over the place. And he became like irrational, he became like irresponsible. And to me, if that is the exemplification of who the leadership of the police service is, then we have problems in this country. That is one aspect of the incident. Number two, yes, I agree there are rules that nobody should walk in with guns. But these are official bodyguards of people who are going to the Supreme Court. These are official bodyguards. And an official bodyguard is known what they carry, they are known what they have, they know who they are assigned to, and therefore if that sign, and I tell you, I was in the Supreme Court in 2013, Debarl, and I was a security consultant to the Chief Justice at that time. And I know the arrangement was very clear. If you're a bodyguard, a recognized bodyguard, you'll walk in your VIP armed, so long as we know that you are the official bodyguard to that VIP. What was meant, and I don't understand what the police were doing, is that anybody who is a licensed firearm carrier is that person who is not supposed to walk in with a firearm. And there's a place actually that I remember was organized in 2013 where you'll come in, hand over your arms in a safekeeping, and when you walk out, you pick your arm and walk away.
Yes.
But it did not affect bodyguards of people who were VIPs at that time. So I do not understand what criteria was used this time by the police that they can even stop official bodyguards or VIP protectors not to walk in with their arms, and yet these are police officers, vetted, trained, and under the leadership of their own senior officers. So all these things it speaks about either one, how the police system views probably members of the petitioning team, and how they also want to look at the other parties involved. Because I'll tell you this, most of those fellows you saw on that court have armed police officers. I can tell you for sure. Majority of them, even some of the senior lawyers, the judges, they have armed police officers. Why? And I don't know what happened. Why should it happen to a bodyguard who is guarding one of the people who are petitioning? And I'm not creating a scenario here or a narrative for Kenyans to talk about, but I think we need to be very cognitive of the fact that the law does not discriminate. So if it says this is how bodyguards are supposed to do, this is how they're supposed to undertake their duties,
right,
I think as a country, Debarl, we must accept that that's what the law says.
All right, thank you.
Yeah.
All right, I don't know if any of you, because I know maybe I'll cross over to Dr. Mustafa and say, you know, I'm not a police officer, I'm not a security guy. Professor Noah Midamba. Noah Midamba has something to say.
No, the only thing I want to add to what our friend Werunga just clearly announced is that we are supposed to be law and order country. And law and order country has to begin from the top down. And police officers cannot behave like rogue thugs. And hence you say we're a law and order country. I think the point Werunga brought home is a senior officer pushing pushing a junior officer, okay, in front of Kenya. Now, I just want to say to Kenya, whatever happened during election, the young lady 6-year-old that was shot, the 6-month-old that was clobbered by Werunga, is not out on the mind of Kenyan people. So this behavior ought to stop, and stop once and for all. Police need to scrutinize its own rank and file people and get rid of this kind of people, because they're giving us a bad image in the country.
Right. Dr. Kisaka, maybe on that particular aspect where we see, even at Bomas of Kenya, we've had police officers, or you had, police officers really complaining that, you know, some of people who are in the upper reaches of government, it could be the CSAs or the government officials, ministers, the governors, they actually, they're quite condescending when it comes to the entrance of maybe restricted premises like the Bomas of Kenya as well, which was access only. And there's clear instruction, yet there was a scuffle because they think they have a right to, and they can talk condescendingly to policemen. So there was those trouble as well. What we saw here happening at Supreme Court was exactly the same scenario that was happening at the Bomas of Kenya. So when it comes to following instruction, even if you're a leader, that yes, you should leave your gun here, this is an access-only entrance, and we don't also we don't really require arms in that particular premise. How should they respond in just following simple instructions, like no guns at a particular premise?
I think what Captain Werunga has said and Professor Midamba have observed to me is very important. As a country, democracy is a system which relies heavily on good values. Respect of the law, respect of persons. There's a way you deal with one another in a civil way. I think in a situation like this, it ought to have been managed by the police, just asking this person, are you aware of the regulation? This is the regulation. And then guiding him on what to do. What they have displayed to Kenyans is that they have no regard for other Kenyans, regardless of who those Kenyans are. And it's amazing, and I've just listened to a captain talk about it. It's like it's only one person who had this problem in the entire event. I think it can be managed differently. We should be a country of values, a country where people respect each other, and not a country where once you are asking anybody, do you know who I am? There's a problem. There's a problem. I think we ought to respect each other and be able to function together as Kenyans.